Statement, and then we will begin the case in chief. This is the commencement of a virtual Zoom hearing by Tri-County Hearing Panel number 55 of the Attorney Discipline Board in the matter of reinstatement petition of David. This panel has been appointed by the Michigan Attorney Discipline Board, the adjudicative arm of the Michigan Supreme Court in attorney discipline proceedings. The panel is comprised of myself, Paula M. Tallarico, as chair, Gary E. Perlmutter, member, and Ethan R. Holtz, member. Counsel for the Grievance Administrator is Sarah C. Lindsay, who will represent the Attorney Grievance Commission, a separate agency acting as the investigative/prosecutorial arm of the Supreme Court in these matters. Counsel for Petitioner is Timothy A. Dinan. As this hearing is being conducted via Zoom, hosting controls of the meeting will be performed by the case manager, that is Owen Montgomery. The hearing will be live streamed on the board's YouTube channel. The parties are asked to avoid excessive over-talking and interruption to keep the proceedings moving slowly. The members of this panel undertake the responsibilities of the adjudication of this matter as volunteers in order to discharge the duties of the legal profession to the general public, which our profession is sincerely dedicated to serve. The purpose of this hearing is to determine whether the petitioner shall be reinstated into the practice of law. This hearing is conducted according to MCR 9.124, parent C, MCR 9.115, and the rules generally applicable to any non-jury state circuit court proceedings. In this proceeding, the petitioner is required to establish eligibility for reinstatement by clear and convincing evidence, and specifically to establish the applicable criteria under MCR 9.123, parent B. The decision of this panel may be appealed to the Attorney Discipline Board by the petitioner or the Attorney Grievance Commission. We will now proceed with the hearing. Mr. Dinan, could you pronounce your last name for me, please?
You're getting it correct. It's Dinan.
Dinan. Mr. Dinan, you represent the petitioner, I understand.
That's correct.
And Ms. Lindsay is here. You have the burden of going forward, and it's your petition, so I will let you just proceed.
Okay, I was just going to start with a brief opening statement, if that's okay.
That's fine.
Thank you very much, and thank you all for being here this morning. Thank you for your preparation for today's hearing. This has been a long 5 years for David Wiz. A drawn-out divorce, money struggles, and the misfortune to have his personal problems roll out in the public is just part of the picture. The hardest part is having your fellow professionals tell you that you're not fit to be a lawyer. The sanctioned conduct that led David to where he is today is tied chiefly to his divorce and its aftermath. It's rooted more in personal conduct than his professional conduct. And no matter what your opinion is of David's conduct, the thing is he has still paid a very high price during this period of suspension. David acknowledges his conduct today and does not blame anyone but himself for the problems that were created and their consequences. His greatest desire is to return to the practice of law, chiefly patent law. He worked in the field for a long time and did so with recognition and success. He's drafted hundreds of patents and understood the engineering intricacy and the ideas that he was documenting and securing for the inventors, his clients. His real skill set lies, though, in explaining these complex concepts and their novelty to the patent office to successfully serve secure patents for his clients. Today is the first step in the process for David to return to practice. He understands that the Board of Law Examiners may require him to sit for the bar again. And even if he should be relicensed as attorney in Michigan, he still needs to pass the patent bar hearing process, which is similar to the one that's being conducted today. Today, you have the job of determining whether David Wiz currently possesses a good requisite character and fitness to return to practice. It's current character that I'm asking the board to focus on, because this is the person who wants to return to practice today. To that end, David's going to present one witness and testify in his own behalf. His affidavit of personal history contains many exhibits which show his current finances and how he's met all the other requirements set forth in 9.123 and 9.124. Again, thank you for your preparation today and for your attention.
Ms. Lindsay, would you like to make a statement?
Thank you. Very sorry, I'm getting a bit of an echo. Are you?
Not too much, but it is slightly interrupted in terms of there's a lot of wind outside, so it might be, that might.
There is. Okay, first of all, I would just like to introduce Kimberly Billings is also on the screen. She is a paralegal with the Attorney Grievance Commission, and she's here just to assist me with putting up any documents if it's necessary. So just so everyone knows who she is.
Thank you for that.
Thank you. And generally, I would just rely on the grievance administrator's investigative report and the supplemental report and all of the appendices that have been put in. I would just very briefly say that although Mr. Wiz does say that this is primarily stems from his divorce, that the most serious of the misconduct and the most recent actually occurred when he was applying for a job and in his last personal history affidavit that he submitted in his petition for reinstatement, which was eventually withdrawn, but the panel found that he lied in that personal history affidavit, and it had nothing to do with the divorce. But we've presented in the investigative report significant issues that need to be addressed, and I would rely on that and then reserve any further argument for a closing argument. Thank you.
Thank you. Mr. Dinan, you may go ahead.
Thank you. My first witness will be David Motto, M-O-T-T-O.
Thank you.
All right, you may proceed.
Thank you. Sir, would you please state your name and professional address?
My name is David Motto, M-O-T-T-O. My professional address is Fujifilm Healthcare Americas Corporation, Niner.
Thank you, sir. And what do you do for a living?
I'm a patent agent, so I'm a engineer who self-studied patent law and successfully passed the USPTO federal patent bar, the same that patent attorneys take.
Okay. What are your major duties as a patent agent?
At this particular position, I was hired for two divisions, Synapse PACS, which is a picture archiving communication system. It's the software that allows radiologists to look at X-rays, MRIs, whatever comes off of the different modalities. Then there's Synapse BMA, which is a vendor neutral archive. So that doesn't care what it is, pictures, PDF reports, videos, it will just archive it. So the two systems work together. On top of that, the divisions that have been added has been endoscopy, Synapse Analytics, and Synapse Pathology. And it looks like also women's healthcare, I started handling them as well. So that's more of like the mammography.
Thank you, sir. Do you know David Wiz?
I do.
And when did you first meet him?
I would say 2007, back when the economy was better. So back in 2005, I was hired at Pratt & Whitney as a contractor. So I worked for 2 years as a contractor at Pratt & Whitney. And then my contract was coming up, and Pratt & Whitney had two patent agents, and one resigned, and I basically filled his position in 2007. So I physically met Mr. Wiz. We had this Rhode Island, they had an annual intellectual property like get together. It was part social, it was part educational. And that's when I first met David Wiz in person.
Okay. What was David doing at the time?
He was, I worked with maybe 4 different outside counsels, and David was with one of the outside counsels. So within the outside counsel, I might have worked with 4 or 5 patent attorneys each. So roughly maybe 16 to 20 different patent attorneys, and he was one of them.
What stood out to you about David Wiz in his role as a patent attorney?
Well, I never had to worry about, office actions not being answered. I myself am an inventor, and what really stood out with me was I had this. So Pratt & Whitney, we manufacture gas turbine engines, jet engines, basically, right? And we had this new engine that used a gear between the low pressure turbine and the fan. It basically slowed the fan down through a gear system. And the gear system generates a lot of heat, and it needs constant lubrication. And sometimes in flight, you'll hit 0G, you'll hit some turbulence. And during that time, you're going to lose lubrication. So one of my ideas was basically an accelerometer and a timer. And if you lost gravity, basically, more than a few seconds, it would open a solenoid valve, and it would have a pressurized lubricating tank. On one side would be a nitrogen charge, separated by a rubber damper. On the other side would be your lubricating oil. So if it timed out, it opened the solenoid valve, and it pushed the lubricating oil into the gear system. And what happened was I had my interview with David, and the draft that came back was phenomenal. It was better than how I described it. And I have, when you read patent applications over and over again, they're kind of discombobulated. They're hard to understand. And this application was fantastic. And not only did I prefer to work with David, but monthly we would get all the new patent applications that were basically the invention disclosures that were approved to be drafted as a patent application. And we would get in a room, we would go over them, and then we would all internally pick the invention disclosures and where we wanted to send them. And typically people would say, send them to this outside counsel. But in David's case, it was send it to David Wiz, and we would have to fight over him.
Now, how long did you work with David when you were at Pratt & Whitney?
2007 until I left in early 2017 for about 10 years.
Okay. Now, do you stay in touch with David?
I do. Yeah, we talk maybe every other month, something like that. Just to catch up. Just his passion for aerospace also really stood out to me. He reads books on it. We would talk about, oh, did you know this and did you know that? And so I learned a lot from him as well.
Now, over the years, have you that you've stayed in touch with him? Has he discussed some of his personal life with you?
He has, yes. Yeah.
How so?
When he got married, when he had his first child, then there were issues with that marriage, and I would basically listen. Personally, I got married in 2012, but we don't have children, so the marriage part I could relate. Yeah, so I would basically just listen, maybe offer some advice. I have a friend that kind of went through a similar situation. Oh, do you want to be introduced to this person? His first name is Bill. That sort of thing. Just lend a sympathetic ear.
I think you already answered this question. How would you describe David's conduct with you from a professional standpoint, not just in the patent drafting, but all the other aspects of working with a lawyer.
Right. So the patent drafting is superb, second to none. Also, when you file a patent application, what happens is you begin to get office actions back from the Patent and Trademark Office. So I would never have to worry about a case that David was handling. I knew that the response would be, superb. I knew it was going to be answered on time. So like I said, I mean, it wasn't just me that was fighting to send him work.
Now, you understand today David's seeking to be readmitted to the practice of law?
Yes.
Okay. Prior to today's hearing, did you have an opportunity to review the Attorney Grievance Commission's report prepared about David?
I did, yes.
Were you familiar with the subjects that were discussed in that report?
Yes, I believe it was roughly 100 pages. I did review it prior to when we were supposed to meet a few weeks ago. And so I'm just going off of memory from that aspect of review.
Was there anything in that report that gives you any hesitation in extending your support for his desire to return to the practice of law?
No. Professionally, zero problems professionally. I would love to work with David starting tomorrow because he makes my job so easy.
Thank you very much for your time, Mr. Model. There may be other questions in the room for you.
Okay, thank you, sir.
Ms. Lindsay?
Good morning, Mr. Motto. My name
Yes,
is
good
Sarah
morning.
Lindsay. My name is Sarah Lindsay, and I work with the Michigan Attorney Grievance Commission.
Good morning, Sarah.
Good morning. So when you were testifying, I actually had a difficult time hearing a little bit of what you said. You said you're a patent agent. Is that correct?
That's correct, yes.
Are you an attorney?
No.
No. Okay. So you have not passed any, did you say you took the patent bar?
Yes. So in the United States, there's a lot of attorneys, but they're not technical. So what the patent office does is they allow engineers. So when I applied to the USPTO, I had to send them all of my credentials. I graduated as a marine engineer from the United States Merchant Marine Academy. It's one of the 5 federal academies in this country. And I submitted all of my, basically, I had to do a syllabus, I had to do all of my grades, and then they green lighted me to take the federal patent bar.
Okay. So you, as part of that, you don't go through the character and fitness and application portion of admission to a bar. Is that fair?
There is an Office of Enrollment and Discipline at the United States Patent and Trademark Office, but I haven't done anything other than submit my professional credentials, basically, my grades and whatnot. But if there's a problem with me, anybody, as I understand it, can submit basically like a complaint.
Okay. So before, I think you told Mr. Dinan that you reviewed the grievance administrator investigative report in this matter. Is that correct?
That's correct, yes.
Okay. Did you receive, or I'm sorry, before looking at that, you said a couple of weeks ago. Is that fair?
Yes.
So before that, were you aware of Mr. Wiz's suspension from the bar?
Only through conversations that I had with him.
Okay. And based on those conversations, what can you tell me about what he said he was suspended for? The reasons for his suspension.
We didn't go into detail, and I didn't ask because I'm a pretty private person, so I don't really want to know the details of people's personal lives. Yeah, I would. That's just I know him professionally and friendly over the years, and that's the extent, I think.
Okay, so you've had no discussions with him about the reasons for the suspension or the conduct that led to it. Is that fair?
Not in detail, on his side, but I did review the document. Yes. The details from the documents is really where I saw.
Okay. When you read those, after that, did you have any conversations with Mr. Wiz about the documents? Did you have any questions or concerns for him that you raised with him?
No, because my parents went through a very, very messy divorce throughout the entire 80s. And we actually ended up, which was very rare at the time, living with my father at the end of that, 1989, roughly. So I just tend to stay away from people's personal messy affairs. It can make people do, maybe things out of character.
Okay, so is it your understanding that the suspension related to a messy divorce?
That's my understanding. That
Okay,
is probably the stimulus, like the stressor that augmented a lot of actions that had taken place.
Okay. Are you aware that he was suspended 2 more times after that?
Yes.
Okay.
When I read through the documentation. Yes.
All right. But again, you've had no conversations with him about those matters.
In detail, correct. Yeah.
Okay. Have you had any conversations with him about changes that he's made in his life, or changes that he's made in his conduct since then?
Well, I would say that the biggest thing and the biggest motivator is that he's remarried with a little boy that he loves them extremely, very much. And I think that's the biggest motivator going forward, where these incidences will not repeat themselves. Logically, I'm thinking as an engineer.
Okay. And nothing that you read, you said, in the reinstatement report or the attachments gave you pause?
No, I can't imagine being separated from, like I said, I don't have a child, but I went through the experience of my parents fighting for custody throughout the entire 1980s. And I just, now during the 1980s, I was seeing both parents. So I can't imagine what that would do if I was in David's shoes and couldn't see my first son, right?
Okay. All right. I have no
I
questions.
I think that kind of can, make people do things that they normally wouldn't do. It's an incredible stressor. So I empathize with people that go through that.
Okay. Thank you, Mr. Motto. I have no more questions.
Thank you.
Mr. Dinan, anything else?
No follow-up questions. Thank you.
Any questions from the panel?
None here.
Okay. Mr. Holtz?
No, thank you.
All right. I believe then, Mr. Motto, you are excused, and we appreciate you taking the time to come and testify this morning. We appreciate it. Thank you.
Okay. You're very welcome. Goodbye now.
Thank you,
Goodbye.
sir.
Mr. Dinan?
I will call the petitioner at this time.
Okay. Mr. Wiz, you're going to have to be sworn in. Mr. Trudell, can you swear in the witness?
Yep. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
You may proceed.
Thank you. Sir, would you please state your current address and who you live with in your home?
I live with my wife, Diana, and son, Alexander.
How old is Alexander today?
He's 5,
Okay.
turned 6.
And what do you do for a living?
Basically, I'm working with Fargo Patent and Business Law, as essentially a patent engineer or a law clerk sort of role
Okay. And how long have you been employed there?
since June of 22.
Okay. And what are you seeking today from the Attorney Discipline Board?
To be reinstated.
Okay. Mr. Wiz, how many times have you been disciplined?
3 times.
Okay.
Hereby-
And have you reported your discipline matters to the U.S. Patent and Trademark Office after the Attorney Discipline Board issued its orders of discipline?
Yes, sir.
Okay. And have you received similar discipline from the U.S. Patent and Trademark Office of Enrollment?
Yes, it's reciprocal discipline.
And have you been relicensed by the USPTO?
Not as of yet.
Okay. Do you desire to return to the practice of law?
Yes, sir.
Why do you want to return to the practice?
Well, I mean, like David Mata was saying, I very much appreciate patent law, and patent prosecution in particular was always my focus. I never really practiced law per se. However, I was licensed in Michigan and licensed by the patent bar. So I was considered a patent attorney rather than a patent agent. There's various restrictions under my suspension with the USPTO that actually even go further than that with the Michigan bar. I can't have contact with clients. I can't perform certain opinions. So they really go hand in hand. So I hope to be reinstated by Michigan so that I can then be reinstated by the USPTO, because the USPTO, again, is based on reciprocity. So if I can get the all clear from Michigan, I should be able to get the all clear from the patent office.
Thank you. Since the enter of the order of suspension on March 11th, 2024, have you practiced the law or attempted to practice law?
No,
Have you held yourself out as a lawyer?
no.
As you consider your 3 discipline matters, do you believe that you were singled out for your discipline compared to other lawyers who have come through our attorney discipline system?
No, I had no issues whatsoever with the patent office or Michigan or criminal system, anything whatsoever prior to the child custody. And, you know, again, as David mentioned, it wasn't as much the divorce aspect as the child custody aspect that really was something I never imagined.
How would you describe it to the panel?
Describe.
The struggle of going through the custody for your son Tex.
I mean, I almost think unless you went through it, you almost can't even appreciate how much pain and suffering is associated with it. I mean, I've always worked from home, so Tex and I were very close. Just very close. And to have that ripped away and have everything becoming public, and dealing with that and seeing him struggle, it was just, I mean, I've had surgery for Crohn's when I was a little boy, and I couldn't imagine how it was on my parents to see their son, who's 9 years old, in the hospital. But this to me had to have been similar, to see him just ripped away and to see him stressed. I almost can't even describe it.
Would you say that you and Ms. Plosky had a great deal of personal animus between you?
Absolutely. She had an affair. She locked me out of my own home. Her family got involved. Her affair partner got involved. It just devolved into this unbelievable antagonism.
Did you feel emotionally prepared to face that? when it first arose?
No, not at all. I mean, my parents were never divorced. I wanted, I just wanted a normal life, basically. And then I had that. It was totally, I mean, like I said, even going through surgery as a child and almost dying really, really didn't compare, because you get better, hopefully. The emotional aspect of it was just way beyond anything I could have imagined.
Now, you were first suspended in October of 2021, is that correct?
That's correct.
And what were the first changes that occurred at that time in your life?
Well, I was working with a law firm that was somehow advised of my suspension because the client, Pratt and Whitney, was somehow advised of my suspension. I still don't know how exactly, but basically, I was terminated from that position based on my suspension, which I think because it went up to the client somehow, the law firm was then concerned, whereas before I had hopes that they would be able to, keep me on as essentially a law clerk at the time. So that kind of came as a shock. And I've never been unemployed before, for one thing, let alone from, a profession that I truly enjoy.
Do you believe you have a clear understanding of what's expected of you if you are given a chance to practice law again?
Yes, absolutely. I mean, like I was saying, the custody battle just, it created such a loss of perspective on me, and the higher standard that I was supposed to meet as an attorney, and I didn't realize it, in the sense that I got so caught up in the custody battle. I mean, I saw a therapist who lied about having a license. I saw her commit perjury with regards to texts being hit. And then the attorney for my ex was the attorney for that unlicensed therapist. I realize now, again, that my behavior is not that just of a layperson per se, but is a higher standard. And that's my focus and understanding. It's kind of like learning the hard way, I guess you'd say.
So why do you believe that you're able to be recommended safely to the public by this board today?
Basically, like I said, I am essentially a new person. I'm remarried. I have a 5-year-old that I love. I mean, maybe not as much a new person, but the person I was before all this happened. And, I acknowledge that I made a lot of poor decisions and was very caught up in the process. And I see that now. I can see that much more clearly. And again, it's been a very hard lesson to learn, but I really just want to put it behind me and move forward. Like I said, I'm working with a new law firm, and I fit in very well. They're a growing firm, potentially, not potentially, but actually. So I just want to move forward and put all this behind me, with the caveat that the lessons I've learned have been learned in a very difficult way.
And the firm you're discussing, the Fargo Patent and Law Office, a business law office, are they aware of this process?
Yes, and in fact, the founder of the firm wrote a letter of recommendation to the board for me for this process.
Now, do you understand that even if you were to be found to possess the requisite good character and fitness to practice law by this panel, that you may still have to sit for the bar exam?
Yeah, I understand that's a possibility.
Okay. And have you paid all the money that was due to the attorney discipline system?
Yes.
Why did it take you until July 2025 to pay on that order from the board?
Mostly I had limited resources at the time. I knew I was going to pay it. I knew I was going to apply for reinstatement, but I kind of had to make some day-to-day decisions, if you will.
Now, do you have any outstanding judgments against you or unpaid debts that are more than 90 days late?
No.
I want to discuss the divorce from Ruth Plosky with you and what the Attorney Grievance Commission has presented from the panel in that regard. I think you testified earlier that the divorce was part of the backdrop to your 180-day consent discipline in 2021. In count one of that, you admitted filing a false marriage certificate with the Oakland County Register of Deeds. Could you please explain the circumstances behind that?
Yeah, it's kind of complex in that I was married prior, and my attorney at the time, who was a friend from law school, she had said that she had entered the proper order of divorce, but she created a false document of the divorce, and frankly, she was suspended from the practice of law for, I believe, 3 years. Cheryl Raymond was her name. And I didn't find that out until my first wife tried to get a marriage certificate, and she came to me and said, "We're still married." And I said, "That can't be possible. You know, I gave you the document." She's like, it is. And so when I investigated it, this is what I found out. And because I was kind of at a loss as to what to do, and we had friends that were, well, one was a pastor of a church. We had them do a new certificate of marriage, and the date I used was the date of the original marriage, which was improper. It was about a year later, I believe, that this marriage certificate was created. So, you know, I was trying to avoid embarrassment and all this dealing with Miss Plosky at the time, because she claimed to be religious and all these other things. And this was just kind of our path forward. So it all had to do with the date being our original date of marriage rather than the date that the new marriage certificate was entered.
Did you talk to a lawyer about this at all?
No, I had a lawyer who did a proper divorce.
That was from your previous marriage?
That's correct.
Okay. So you got it straightened out, but this was something you did yourself, and you did it in order to avoid embarrassment. Is that correct?
I mean, essentially, you know, we had asked the judge to just reinstate the Plosky marriage as being the proper marriage, and that wasn't, the judge didn't agree to do that.
So the second count of that first discipline dealt with the taking of a notebook from Ruth Plosky during a break in a deposition. How do you see and explain that today?
Well, there's basically a court order for her to turn over her notebooks and for her to bring notebooks to the deposition that were not turned over, I thought was just antagonistic. Just the point that she was ignoring a court order to turn over notebooks. And I thought that as an officer of the court at the time, I could take the notebook. And it was investigated by the sheriff's department. Nothing ever came about it, came, from criminal matter, nor did anything come from the actual court in the child custody case. So, I guess I did sort of self-help, if you will, that again, it was just the frustration of dealing with her, and that was just such, just one example of the kind of games that were being played that, again, I kind of just lost perspective and I thought I could just take it.
Okay. Were you ever ordered to return the notebook?
No.
The third count in this 100-day suspension regarding the testimony about Mark Polikas. Can you please explain that to the panel and explain how you see that today, your conduct in that incident today?
Well, that was the guy my ex Plosky was having an affair with, and he was a felon. Well, he was convicted of a felony, and there was a mutual restraining order between my ex and myself. So we couldn't, enter near each other's property or anything like that due to the mutual restraining order. So basically she used him to come to my house, to follow me, to do things that she herself wasn't allowed to do. And again, it was more just antagonism and more attacks on me through him. And frankly, I was terrified of Tex being around him. And he lived in Birmingham in a rental as well. So because Plosky lived, or still lives, in fact, in I'm blanking on where she lives now, Farmington Hills, excuse me. He was relatively close to me. So he would pop up, Tex and I would go to the farmer's market in Birmingham, and coincidentally he'd be there. Just things like that. The particular incident that you're referring to is that I had met a girlfriend at the time at Meadowbrook with Tex, and that was arguably not allowed in the judgment at the time. But even that was not clear. I was never disciplined for that or whatnot. But during a PPO hearing that Polikas filed against me, which again was, in my mind, harassment because nothing came of that either, there was a question about, was I ever with Tex and a girlfriend? And I had just answered no. So, that was again me just not answering explicitly properly. And it was a misrepresentation, and I see it now, and I should have just been more forthcoming at the time. So that's that portion of the event.
Thank you. As you look back on those three different incidents, how do you characterize your personal conduct during the divorce compared to your professional conduct as a lawyer?
Well, that's just it. I mean, my personal conduct was, not right. And I never had any issues with clients or professional conduct whatsoever, but my fault was not realizing sort of the overlap of being an attorney and how my personal conduct would reflect on that, because I always kind of separated them. And like I said, I see now the overlap and see how my standard of behavior had to be much higher. And in fact, I don't know if you're going to ask about, but the recording.
Why don't you tell the panel about that, please?
Well, my son was complaining about being hit, and I know for a fact that my ex's family used physical discipline, and so we put in the judgment of divorce that there's no physical discipline to be used whatsoever. And he told me that he was hit in the face for saying, "Oh my God." And like I said, they present themselves as being religious. So that was considered blasphemy. So the fact that he said he was hit in the face for doing that, I honestly believe that, because I saw the father, my ex's father, strike another one of my ex's siblings' children for spilling talcum powder. I saw that myself. And I conveyed that to the GAL and to the psychologist, who again turned out to be unlicensed. And I asked them about it, and they said, "Oh no, he's never said such a thing." And again, I believed Tex more than these people. So that was before I knew anything about the unlicensed nature of the therapist. So I didn't know what to do. So I did some legal research, and I basically found a case. I think it was Pollock, something like that, about a parent could record a child's phone call. And it was essentially like vicarious consent, because the minor child couldn't consent. So I was standing in the place, and it was essentially like vicarious consent, because the minor child couldn't consent. So I was standing in the place, and I decided to record Tex when he was in so-called therapy. And she asked him about the question about being hit, and he said he was hit. Again, it was a self-help sort of thing, but I thought I had some legal standing to do it. Case law. We then filed an emergency motion about this, and I was the one that was given basically supervised parenting, which only added to my sort of distraught with regards to the child custody battle and the system, when I had all this evidence and nothing essentially was done. I mean, I realized that there are probably other ways to pursue it, but I was at a loss. And kind of the engineer in me was, well, you need third-party evidence. And that was my process to get that third-party evidence. And in fact, when the so-called therapist was asked about it in her deposition, she just blatantly lied about Tex ever saying that. So it wasn't even based on the veracity of what Tex was saying. It was, no, he never said such a thing. And I just couldn't believe that I was sitting in a deposition watching someone just commit perjury in front of me. And like I said, this is a hearing about me and my mistakes and what I did, but I'm just trying to convey like this sort of distraught nature of things that were occurring, and the emotional damage, I guess, or the emotional impact that it was having on me.
Now, you received a 30-day suspension for conduct related to a March 2022 conviction for disorderly conduct in Rochester, Michigan. Can you offer the panel insight into what happened that day and how you became embroiled with the driver of the vehicle?
Yeah, I mean, basically, I was in downtown Rochester. I was just walking across the street to a coffee shop, and I was crossing the street with the light, and a car went past. And then another car went past and almost ran me over. Like, I was just crossing the street, and this car just barreled around the corner, almost ran me over. So I yelled at the driver, and I used like a racial epithet, and I was just startled. I went into the coffee shop after, and the driver came into the coffee shop and accosted me and started yelling at me. And, again, I'm sure I was under stress from this whole situation, and I kind of yelled back. So that's the background of it. Again, I wish I would have thought more that my standard is not just of a layperson who can get into sort of a disorderly conduct with a random person on the street. But again, I couldn't believe that someone basically got out of the car and followed me into a coffee shop to attack me when they almost just ran me over. So I was just kind of caught up in it.
What happened in court?
I pled to disorderly conduct. I tried to take responsibility for my actions, and I accepted that.
What were you sentenced to by the court?
1 year of probation and anger management training, basically.
Did you complete the anger management training?
Yes.
Have you ever had anything like this happen to you since that time?
Neither since nor before.
Now, the 18-month suspension that was imposed upon you after you sought and received a job at Gentex, you went to hearing on this matter, and testimony was taken from you and the parties involved. Your interest at getting a job in Gentex arose shortly after the 180-day suspension was imposed. So can you please tell the panel the circumstances on how you started to look for a job, how you went to Gentex and went through their hiring process, and ultimately ended up being offered a job?
Yeah, well, my prior firm was not doing so well as far as getting work from outside from, well, it was UTC at the time and then Raytheon. So I had put my resume up. Well, I put my resume into Indeed. It wasn't public. But then when the termination happened, I started just looking at Indeed because I still had my patent bar license. So like David was mentioning, I was still a patent agent. So I didn't have my law license, which was suspended, but I had my patent license. And so I was looking around for a position as a patent agent, and Gentex, even though the position called for a patent attorney, everything they had as far as roles and responsibilities was patent agent work. So I applied just to see. I was kind of at a loss as far as what to do. And I thought, if I could get a job as a patent agent, or I could get in with a company, I could kind of prove myself and then convey the suspension aspect of it. Again, it was me sort of being a little desperate and cutting corners, and realizing now that I should have just been upfront from the beginning. But sort of the dichotomy between patent agent and patent attorney is sort of what I relied on to pursue that role with Gentex.
So were you ultimately offered a position there?
I was.
And how long did you work there for?
Really, I think only a week or so. It wasn't a good fit. And part of what I mean, it was a 2.5 hour drive from Birmingham. So I discussed, working remote with them. And so they agreed to it in part with regards to, okay, well, work on site for 6 months and then you can work remote. So one of the days, something was going on with Alexander, and I just said, hey, I'm going to work from home today. And basically the next day they terminated me because essentially I work from home. And that's how that came to an end.
Okay. And after that job, you found a position at the place you're working currently?
Right. And I was like very upfront with them as to the whole situation. They're in Fargo. It's a good fit. And like I said, the attorney there wrote the letter of recommendation, if you will. I'm not sure what you call it, but to the present board.
All right. Now, your 2015 divorce case has a divorce judgment entered, correct?
Yes.
And throughout the years, there's been a number of post-judgment issues that have brought to the attention of the court. Is that correct?
Yes.
Are you familiar with the court order dated November 22nd, 2022, entered by the judge on this divorce case?
That was 4 years ago, but yeah, I mean, that was the custody, one of the custody hearings where I was pro se.
Okay. And I think you've made mention of it, but child custody was highly contested between you and your former spouse, correct?
Yeah. I mean, she lives with her parents and has put, I don't know how much resources into preventing me from seeing texts.
What was it about that upset you?
Well, I mean, a lot of things. I mean, text is now in a completely different environment, in a so-called religious environment that is very different from my idea of raising children. It's exceedingly stressful to think about what he went through. And I kind of had to just let go. I mean, I kind of had to move on, if you will, no matter how, I mean, I don't even know how that sounds. I mean, he's still my son. I still love him and think about him all the time, but the antagonism, I tried to think to myself that I'm kind of pulling out of it, and maybe that's a better situation for him. I'm not sure exactly if that answers your question.
Thank you for your answer. You don't see your divorce as something that was solely caused by the actions of your former spouse. Is that correct?
No, but I tried so hard to just not have it impact text and have things be 50-50. The original consent judgment, everything was 50-50. And I kind of thought that would be the end of it. My ex didn't think the same. And that's where the battle started again. I don't know. I tried to separate the divorce aspect from the child custody aspect. But apparently that wasn't how she thought of it.
Now, over the period of the divorce, two lawyers that represented you sued you for services rendered. The first suit was filed by James Alley. Why is it that you disputed his work and did not pay him until after he initiated the legal action against you?
$15,000 retainer that he basically burned through in a matter of months, and all he did was write letters and talk to opposing counsel. So I was exceedingly frustrated with the amount of money that was being spent for the work being performed.
Did you ultimately pay him?
I did. It was settled for less than. Yeah.
You were also sued by Trisha Hash. Why did she have to sue you to get paid?
Similar thing. I tried to make a payment through a financial advisor. I know that's in the package. That was one of the issues, monetary issues that I was having, where he said a wire was sent to pay. It never was sent. She showed up on the first day of the hearing that you're referencing and withdrew. She then put forth like a $36,000 bill. And again, I was just shocked by how much the bill was compared to the work being performed. So I was contesting it and going back and forth with her on that.
Okay. Now, in one point in the AGC's investigation report, it's taken issue with the fact that you've not sought professional counseling for any issues related to mental health, substance abuse, or addiction. Did you ever seek professional help as it related to the things you were going through during your divorce?
When it first happened, I unilaterally did to someone in Birmingham, and frankly, I didn't really see any benefit to it. Then there was a court order for both of us to seek therapy, and the therapist then, because there was a GAL, would communicate with the GAL, and things that I had talked about with the therapist seemed to have popped up with the GAL. So it left a very bad taste in my mouth on that front. So once that court order was fulfilled, I never went back for therapy. And then you add that to the supposed therapist of techs turned out to be unlicensed. I just found that they have their own agendas, if you will, that I really had no interest or appreciation.
Now, is there currently any money due and owing in Oakland County on any open orders or sanctions from the court?
No, because if there was, I would get show cause right away.
Okay. That's all the questions I have in director. Maybe some other questions for you, Mr. Wiz.
So, Ms. Lindsay?
Yes, thank you. Good morning, Mr. Wiz.
Hello.
So the first thing I want to ask you about, Mr. Dinan asked you if you reported your misconduct to the USPTO, and you said yes, all three. Is that correct?
Yes, Mr. Dinan reported them to the PTO.
Okay, but the USPTO has not issued orders for the second and third, the 30-day and the 18-month suspension. Is that correct?
Correct.
Okay, so the only thing that USPTO has currently is the reciprocal 180-day suspension.
That's correct.
And other than your understanding that Mr. Dinan reported them, do you have any evidence of having reported them?
Whatever he has.
Okay. You talked about your desire to return to the practice of patent law, to return to practice before the USPTO, correct?
Correct.
you have never practiced in a Michigan court. Is that fair?
Yes.
And you don't really practice state law.
No. I mean, like I was saying at the beginning, my Michigan license allowed me to be a patent attorney rather than a patent agent.
Okay. So you could petition for reinstatement to the USPTO and be allowed to be a patent agent. Is that true?
Well, basically because it's reciprocal discipline. As I mentioned earlier, if I get the all clear for Michigan, then I should be able to get all clear from the patent office, which is federal. I'm not sure what would happen if I tried to apply with the patent office while the reciprocal discipline is still standing.
Okay, but as you said, they do have their own separate office for admissions. Is that correct?
Yes. Like
so I think your witness, Mr. Motto, said he went through that process and is not admitted in any state court. Is that fair?
Because he's a patent agent.
Okay. So he was able to go through just the USPTO process and become admitted as a patent agent through their process.
Correct.
Okay. You also said that you believe the restrictions with the USPTO go further than Michigan. And one of the things you cited is you can't have contact with clients.
That's correct.
All right. Do you understand that under the Michigan license suspension, you are also not supposed to have contact with clients?
Yes. Yeah. But my point is that the firm that I'm working with doesn't it's in Fargo, so it's a completely different situation.
Okay. I thought you were saying that the USPTO suspension goes further than the Michigan suspension does in terms of restrictions.
Well, yeah, I mean, in my mind, there's things like it's not just practicing before the patent office, but I can't even talk to someone who may be a client for the patent office.
You understand that that's a restriction for the Michigan bar as well, correct?
Yes.
Okay. Mr. Dinan asked you specifically if, since your last order of suspension on March 11th, 2024, whether you have held yourself out as an attorney, and you answered no.
Correct.
Do you remember that? Okay. So my question is, you would agree with me that you have, in fact, held yourself out as an attorney since your 180-day suspension went into effect in 2021, correct?
What do you mean?
Well, the basis of the 18-month suspension, one of the aspects.
Yeah, you're talking about Gentex.
Yes, sure.
Yeah, well, right. And that's, I agree that I should have been forthcoming that their job description was for a patent attorney, not a patent agent. But I was never asked the question and I never volunteered it. And that's where I made the mistake that I should have just volunteered it at the beginning.
Well, just so the record is clear, the report on this matter is part of the record, but it specifically says that being a licensed attorney under a state, Michigan preferred, was one of the criteria for the job for the patent attorney position, correct?
Yes.
Okay. And you submitted a resume that specifically listed your Michigan bar license as current, correct?
That's correct.
Okay. Yeah. And then during the lengthy process of interviewing, you never told them your Michigan license was suspended.
That's correct. That's what I said. I didn't hear it. Yeah.
Also during that time, you said your USPTO license was still active, and that was technically true at that time. But you knew that the process was undergoing for your USPTO license to also be suspended, correct?
That's correct.
Okay, so You also didn't reveal to them that had you received the job, which you ultimately did, that soon your USPTO license was also going to be suspended.
Right.
Okay. Then you said that the job lasted for a little over a week. I think the record is it was about 12 days, but you were fired by Gentex because you didn't come into the office when it was an in-person position, correct?
Correct.
All right. So it had nothing to do with them learning that your license was suspended.
Correct.
So even after you began working there, you still did not tell them about the license suspension, correct?
Right. That's where I looked at it the wrong way and thought that, hey, if it's a good fit, if I prove myself, that's the time for the conversation instead of kind of proactively, which was poor judgment. I agree.
The 18-month suspension, I don't believe you talked about this with Mr. Dinan. So let's talk about the rest of that. In addition to the holding yourself out as licensed in the state of Michigan, you also then submitted a petition for reinstatement to the Attorney Grievance Commission and the Attorney Discipline Board, where you lied about your employment history, correct?
You're referring to Gentex?
Well, I'm just referring to the findings of the panel.
Well, I mean, yeah, I mean, I guess it was a lie that I didn't put forth the Gentex issue on the petition for reinstatement.
Well, you not only didn't list them, but you said unemployed since.
Right. And yeah, that's correct. Also, I didn't, since it was only 12 days, as you said, I didn't really even think about it as an employment, which again was wrong.
There was findings as well in that you had worked for a group called Volta Law Group as well, correct?
That was, that was kind of like piecemeal work, though. That was not attorney work. That was, like onesie, twosie, and you write a patent on this or that.
You're aware that the panel's findings specifically said that you should have reported that and did not.
Yes, that's correct. I should have reported that too.
There were other positions that you've talked about where you maybe wrote a patent for an attorney. None of that was listed either, right?
Well, that's Volta.
Okay. So you're aware that those findings that the panel found that was an intentional omission and an intentional misrepresentation on your petition for reinstatement the last time.
Yeah, that's why it was 18 months.
Right. And then you eventually withdrew that, but not until after a formal complaint was filed about your conduct. And then you withdrew it. Is that a fair characterization?
Yeah, because it was a mess.
Okay. So I thought I heard you say to Mr. Dinan that you were working with a law firm. So when your license to practice became suspended, what was the name of the law firm you were working with?
Bachman and LaPointe.
Okay. And I thought I heard you say that someone advised them of the suspension.
Someone, before it even came to pass, somehow the client knew about the suspension. That because it was by consent, so it was going to start at a later time.
Okay, so from what I understand, because there was some litigation about this in your divorce, you blamed your wife for reporting your suspension. Is that fair?
I blame my wife's attorney. That's because that's the only person that I could think of that had that knowledge that would do something like that. And I had all these people on a Christmas card list, which was on a computer that my ex-wife Plosky took. So she had the contacts at Pratt & Whitney at the time. So maybe I was wrong. but that was my presumption.
So if that had not happened, do you believe was it your intention to continue working at the law firm despite the suspension?
Yeah, I had discussions with the partner, George Corey, at the time that I could have been doing what I'm now doing at Fargo, in that working as a clerk until the suspension ran.
Okay. And so what I think you said was because the client became aware of the suspension, then it became impractical or impossible for you to continue at the firm?
Yes.
So was it the plan that the client wasn't going to be informed about your suspension?
We didn't really have a plan at the time, but yeah, we would have told them from our side and what we had worked out in Bachman and LaPointe.
Okay, but that couldn't be done after they became aware of the suspension from another source, is what you're saying?
No, because it got raised to a higher level for some reason. And recall that technically Pratt & Whitney, UTC, wasn't my client, it was the firm's client, and Bachman was approved outside counsel. So, like I said, I don't know how it transpired, but that's what happened.
All right, so I want to go back to the 180-day suspension and discuss a few issues with that. When you came in, or when I took your sworn statement back in December, you told me that the 2009 forgery was actually done by the pastor. He put the wrong date.
He put the wrong date because he asked what date to use, and I told him to use our marriage date. So, I mean, ultimately it's my responsibility, but I didn't think that it made a difference when we actually had the ceremony on that date. And this was more of just doing the paperwork, if you will.
So have you had a chance to re-review the consent order and the formal complaint on this matter that was put in the grievance administrator's supplemental report?
Yes.
Okay. Do you agree that, in fact, you were the one who obtained the second certificate of marriage, that you brought it to a Bible study class and had the pastor, Miss Plosky, and two parishioners sign it under the guise of clearing up a paperwork issue regarding the first certificate?
Yes.
So there was no second marriage ceremony at all, correct?
Well, there was, in that we were all together. I mean, so it was like a Bible study thing. So I don't know what you'd classify as a ceremony, but yeah.
So when I saw the word guise under the guise of clearing up paperwork mistake, I don't envision another ceremony.
Right. It wasn't right. We didn't have like a wedding ceremony, but we were all together.
Okay. So from my understanding, your wife was never informed about the problem with the first divorce at all. Is that fair? Let me rephrase that, because never isn't quite right. She was not informed at the time in 2009 about the fact that you were not properly married to her.
That's true.
Okay. So she did not take part in a second marriage ceremony because she wasn't even aware it was a marriage ceremony at all, correct?
Well, she signed the document.
She signed it under the guise of clearing up a paperwork issue.
Well, yeah.
Okay. She was never told, at least not at that time, that the first divorce wasn't actually in effect, and that so technically when you married her, you were still married, technically.
Right. And I didn't know that either at the time.
Right. And so rather than go to her and the pastor and explain the situation and say, here's what happened, you didn't just tell them and then have a second actual marriage ceremony, correct?
That's correct. I wish I would have, because
Okay. So instead, you hid it from your own wife and the pastor, and you actually are the one who wrote the wrong date on it, correct?
yes, yeah, I'm taking responsibility for that. And like I said, because of the religious nature of them, I thought that that was the best way forward at the time. I mean,
So the wrong date was actually, and the only way this could have been cleared up is if you put the 2009 date, correct?
if I would have put the actual date that we filled out the paperwork, there would have been no problem. But instead of the actual date that we filled out the paperwork, I put the original date of our marriage ceremony.
So that's not what is the admitted conduct in this case. The formal complaint said that you corrected the date and you put the current date on the second marriage certificate and not the original date. And then you filed it. I'm happy to bring up Appendix R if we need to look at that.
Okay.
This is the formal complaint that was filed regarding all of this conduct, of which you entered a no contest plea, correct?
I believe so, yes.
Okay. So, Kimberly, is this something that you can pull up or do you want me to? It's Appendix R was part of the supplemental report or was appended to
Yes,
the
I'm pulling it up right now.
Okay, thank you.
Madam Chairperson, while the AGC is getting their document, can we take just a 5-minute bathroom break?
Yeah, I was going to call one after this. Is Miss Lindsay, is that okay? That'll give you enough time to get the document, okay? Fixed around.
Okay, sure.
Sorry.
Well, if you want to keep going, because you're in a groove here. So why don't we keep going, and then right after that we'll take a break.
Thank you. I appreciate that, and I'm sorry to interrupt you, Sarah.
No problem. I just think since we're on this subject, let's finish this and then we can easily take a break for sure.
All right, I think that's fine.
Thank you.
Go
So
ahead.
if you would look,
Okay.
sorry,
Can
paragraph
you
16.
see it?
Yes.
Okay. Mr. Wiz, you see this on here and it says in or about September 2009, respondent, that's you, correct?
Yeah.
Brought the second certificate of marriage to a Bible study class and had Pastor Michael Martoria, Ms. Plotsky, and 2 other parishioners signed it under the guise of clearing up a paperwork mistake regarding the first certificate, correct?
Yes, I just don't like the term guys, I guess.
I understand. Paragraph 17 also says, respondent falsely wrote on the second marriage certificate that the marriage between respondent and Ms. Plotsky occurred on September 13th, 2009, correct?
Correct.
That was not the date of the original marriage. That was the date that it was signed by all the parties, correct?
Now I don't recall because I thought that I had put the original marriage date on the document.
So if you had put the original marriage date, you know it would have been invalid because you were still married, correct?
Well, except that the original marriage was yeah, I guess I didn't think about that at the time, but you're correct.
So there would have been no reason to do a second marriage certificate if the original marriage was valid with the original date. The only reason to do this was to put a new date because it had to be after your divorce was effective, correct?
Right, but if the first divorce was effective on the right date, it wouldn't have mattered anyways.
But you learned after you got married to Miss Plotsky, you learned you were not technically married from your first wife, correct?
I was not technically what?
I'm sorry, you were not technically divorced from your first wife.
Yes, correct.
Not technically, you weren't actually divorced at all.
Correct.
And
Well,
so
Yeah,
in order,
it was technical in the sense that I thought we were.
so I understand that, but you learned that original divorce document that you had been given was forged by the lawyer, right?
Right. Yeah.
And then, so you needed to correct this because otherwise you would have been married to two people at the same time.
Correct.
So you had to put a date after the July 19th. And if you look at paragraph 14 on the screen, July 15th, 2009 is the date that the real judgment of divorce was entered, correct?
Correct.
So it had to be after July 2009.
Correct.
Okay. So you did this without the knowledge of your second wife, Miss Plotsky, getting her to sign it, getting the pastor and two parishioners to sign it. And then you later said you had a marriage ceremony, but you did not, correct?
Well, I considered that a marriage ceremony when we were all together, but yeah, otherwise that's correct as far as the dates.
Okay. Thank you, Kimberly. We can take that down. And if people want to break now would be a good time.
Yeah, I think we can take, let's see, it's 11:11. Let's go till 11:20 and reconvene back here at 11:20.
Thank you.
Thank you. Miss Lindsay, you were questioning Mr. Wiz.
Thank you. All right. Mr. Wiz, the conduct that we just discussed right before the break, that occurred in 2009, correct?
Correct.
Would you describe the divorce from your first wife as fairly amicable?
Completely amicable, and she even testified on my behalf against Mrs. Plotsky when they deposed her.
Okay. And in 2009, things were still obviously going well because you were just getting married with Miss Plotsky as well, right?
I mean, that was a long time ago already, but there were issues at the time, and part of it had to do with the religiosity of her and her family, and kind of like evidenced by what was going on with that, where I just thought a shortcut was better than just explaining it. I mean,
okay. So the next act of misconduct that I want to talk about was the taking of the notebook. This was your then ex-wife's notebook, or soon-to-be ex-wife's notebook. Correct? Okay. This took place during your deposition. Is that fair?
correct.
And there was a break in the deposition.
Correct.
Everybody left the room
Correct.
except for the except for the court reporter. Correct?
Correct.
All right. And then you waited till everyone left the room, then went back in the room and retrieved the notebook. And you took this out of your wife's bag or purse, correct?
Yeah, it was like a briefcase.
Okay. I believe you called it a journal.
Yeah.
But the only thing in the record is that it contained her personal notes regarding strategy and privileged discussions with her attorney, correct?
Well, that's what she said, but it actually contains stuff about her going on vacation with Palukis and presumably texts and other things that were, kind of I guess, more personal nature.
Okay, so that's not in the record anywhere, correct?
I understand, but I'm answering your question.
So my question was actually, the only thing in the record is that it contained her strategy and privileged discussions with her attorney. Right.
That's how she characterized it. Correct.
Okay, so that's actually how it was characterized in the admitted formal complaint.
I understand.
Okay, so that's the record in this case is that it contained attorney-client privileged communications.
That's what's in the record, correct?
And You never returned the notebook, correct?
Correct.
And there's actually a finding that this constituted larceny, a crime, correct?
No, I don't believe there was any finding of along those lines.
In the attorney grievance proceedings and in the admissions and in the order of suspension, it contains the finding that this was larceny, correct?
If that's the language used, I'm not disputing that. Yeah.
Okay, the 180-day suspension was based on a consent order, correct?
Correct.
And you agreed, at least pled no contest to all the allegations of the formal complaint and all of the findings of misconduct, correct?
Correct.
And there was a finding that this was larceny.
Okay.
Do you want me to pull that up, or do you remember that?
I mean, I don't remember it, but just like, under the guise, it's a similar thing where, yes, I guess technically it would be larceny, but there was never any, criminal proceedings. The court never chastised me, anything along those lines.
So I understand that a criminal action was not brought. My question really just relates to the finding of larceny in the attorney grievance proceedings.
Yes.
Okay. There was also a finding that the changing of the date and submitting the record, the public record that you did, was forgery.
Yes.
You
Found those
testified.
bigamy too, but I mean, there's a lot of terminology used.
Okay. I don't think the bigamy finding was in the order, but I do believe that the forgery and the larceny findings were in the discipline order.
You could throw out a lot of terms. So.
Okay. So you testified back in December, and I think you repeated it today, that you believed as an officer of the court, you had the right to take this notebook from your wife's purse or briefcase while nobody was looking, correct?
Well, the court reporter was there, and like I said, there was a court order that she was to turn over journals, notebooks. She was a prolific writer of journals.
Okay, so my question gets really specifically to, you believed that you had a right to take it as an officer of the court.
Yes.
You were not acting as your own attorney at that time. Is that fair?
That's correct.
You were represented?
Yes.
Okay. But you believe that as an officer of the court, if a party does not turn over discovery, that you have the right to self-help or to just take it. And that's your testimony today, correct?
That's correct.
Okay. Even if it constitutes larceny, that's something that an officer of the court can do?
Well, like I said, the larceny term was used, but certainly at the time I didn't think, I'm going to commit a larceny by taking this.
So the next finding in the order of the 180-day suspension was that you sewed a recording device into your son's clothing.
Correct. Well, it was in his backpack.
Okay. You sewed it into his backpack that he then took into his therapy session.
Correct.
And you listened to this private conversation.
Well, like I said, I don't think it was a private conversation because of vicarious.
I'm sorry, the last little bit, I didn't hear it.
Because of vicarious consent, I didn't think it was a private conversation. He's a minor. He was a minor at that time. Well, I guess he's still a minor right now, but yes.
You were not invited into the therapy session, correct?
That's correct.
You were not a party to the therapy session.
Vicariously, yeah, I considered myself to be a party to it.
Okay. You know that there was a finding there as well of wiretapping, essentially.
In the consent judgment you're referring to?
In the consent order of suspension, yes.
Yes. Yes.
So I don't think that there was any discussion of another aspect of the order of discipline, but there was a finding that there were multiple violations of court orders by you.
Yeah, there were multiple violations of court orders for both sides. At one point, my ex had a bench warrant put forth on her for not showing up to a deposition. So yeah, back and forth.
Does her violations of court orders justify yours?
Not at all. I'm just giving you kind of what was taking place at the time. And I take responsibility for my actions. I'm just trying to give you a flavor of what it was like and the things that were going on.
So one of the violations was that you had a private investigator follow Ms. Plotsky in violation of an order, correct?
I don't believe that that order was until after, because we both had PIs following each other. And then I believe that the order said no more private investigations, and it stopped.
Okay, well, it was one of the findings, and we can look at that if you would like, but it was one of the allegations of the formal complaint, and all of those allegations were admitted and were part of the order of discipline.
Okay.
Do you want us to pull that up?
No, I understand what you're saying.
Okay. And you're aware that the Court of Appeals in this matter, the Court of Appeals, you appealed the order of the court, and the Court of Appeals found that you refused to follow the trial court's orders, and their words were as a matter of course. You aware of that?
Yes.
Okay. So there was also the testimony about during the PPO matter where you provided false testimony, correct?
Correct.
I think you described it as not technically correct, but it was false testimony, right?
Well, in the sense that if that was in the consent order, then I agree. But I was again trying to convey that it wasn't, it was what the circumstances were about that event. Or yeah.
So you testified untruthfully under oath when asked whether your son was ever exposed to a girlfriend. Is that fair?
Yes.
Okay. So the 30-day order of suspension relates to an incident that took place while you were already suspended for 180 days, correct?
Correct.
And you had not, obviously you hadn't been reinstated because so you were suspended from the practice of law. You described the incident to Mr. Dinan today. Have you read the Grievance Administrator's report and the supplemental report and appendices that were submitted?
Yes.
You're aware that both the hearing panel that imposed the 30-day suspension and the circuit court judge in the parenting time matter, both upon reviewing the underlying record of that arrest, believed that your description of events was not plausible?
I don't think they used the words not plausible.
Okay. They found it not credible?
What was the exact language? I mean, yeah, I guess they would use credible.
I believe it's cited in the report that the judge found it not plausible and that the hearing panel found it to be an aggravating factor, your lack of credibility and lack of honesty with regard to your description of events.
Yes.
That the circuit court judge also said you testified, because you testified in your parenting time proceedings about the circumstances that led to that arrest and conviction, correct?
That's correct.
All right. And do you know that she said you made numerous false statements throughout the course of the day that you were arrested and made false statements to law enforcement agents investigating a crime, that she made that finding?
You're talking about in the child custody matter?
Yes. Yep.
Yeah, I'm not sure what the exact language was, but yeah.
Okay, did you review the order that we attached at Appendix G, which was the opinion and order following evidentiary hearing on parenting time, attorney fees, and sanctions?
Yes.
Okay, so in there, she specifically addressed your testimony about that day and found that you made false statements on the day of the event to law enforcement.
I don't recall that exactly, but I mean, if that was a finding, that was a finding, but I don't think that that was correct.
Okay, do you know that she also found that you had a rude and aggressive attitude towards everyone around you on the day of the event?
Yeah, I mean, if you're going to use subjective words, sure. I mean, you could say that about a lot of things.
You agree you made a racial insult, I think was your word, at the person who you said almost hit you.
Yes.
You called him a name, a racial name.
Yes.
And you blamed this on the stress of the divorce?
Well, yeah, I mean, I don't even remember what it was, but I just remember it was some other decision or some other negative outcome associated with the child custody hearing.
Okay. Sorry. Have you reviewed the Appendix N, which was submitted with the reinstatement report? This is a letter that you submitted to the panel. You and your attorney submitted to the panel in order to get them to agree to the 30-day suspension that the parties had proposed in that matter.
The consent discipline?
Yes, for the 30-day suspension.
Yes.
Have you reviewed that letter?
I mean, I might have like 3 weeks ago or so when we first were scheduled for this. Yeah. I mean,
okay. So this was a letter that the parties were asked questions about the 30-day suspension, and we needed to submit written information to the panel to get them to agree to the 30-day suspension. Is that roughly the reason for that letter?
Yeah, I'm not sure exactly how the process works, but yeah, that makes sense.
Okay. And in that, you signed the letter?
Yes.
Okay. In that letter, you said you were seeing a counselor focused on marital and family issues.
At the time, yes.
That was November of 2022.
Yeah.
Okay, so I asked you in December, and I think your attorney asked you today whether you've seen any therapist since the court-ordered therapy, and you said no, because you did not find it helpful and you don't have any trust in therapists or something to that effect.
Correct.
And that I asked you, when was the last time? And you said you thought it was, last time you saw a therapist was about 2019 or 2020, whenever the court ordered requirement ended.
Correct.
So in 2022, you told the hearing panel you were seeing a counselor or therapist.
Yeah, I mean, I might have been wrong about the date.
Well, I just want to. So Appendix 9 at page 2, you specifically, your attorney wrote the letter, but you signed it, right?
Correct.
And it says the respondent entered into anger management counseling as a component of his probation terms and completed that program successfully. He now sees Dr. Brenda O'Brien.
Oh, but that I recall that now. Yeah, Dr. Brenda O'Brien, she was also one of the supervisors, and we had a good relationship. I had a good relationship with her. She was and is, I guess, a therapist. So yeah, I would pick up the phone and talk to her about issues that would occur. That's true then.
Okay, so just continuing with the end of that paragraph. He now sees Dr. Brenda O'Brien. He made his acquaintance with her through the divorce and child visitation process. She is counseling him on these core issues.
That's true.
Okay, so when I asked you in December whether you had seen any therapists since 2020, you said no. And I believe you testified today that you had not seen anyone.
Yeah, I mean, the dates I'm not too sure about, but like I said, I would telephone her and talk to her about things. So, whether it's official or seen, I don't know quite how to characterize it, but she was someone that I did speak to from time to time on those issues.
When were you married the third time, your present wife?
8 years ago. Let me see what I have now.
So is that 2018?
9/30/2017. September 30, 2017.
Okay.
As you can tell, I'm not great with dates.
That's okay. I wanted just a rough idea. Wasn't trying to quiz you on the date. All right. So talking about the third, we already discussed it, so I don't have many more questions about the third order of suspension, the 18 months. You agree that you submitted a false resume, correct?
Correct.
And then you submitted a false affidavit of personal history to the Attorney Grievance Commission.
Yeah.
Okay. Let me just review my notes real quick. You discussed the dispute you had with the attorney, James, is it Ali?
Yeah, I'm not sure how you pronounce it.
Okay, but it's A-L-L-E.
Yes, ma'am.
All right. You said that he burned through the retainer and you were frustrated, so you didn't pay him. Is that roughly what you testified?
Yeah, I contested his bill and what he was billed.
Okay. Is it fair to say that in fact you made a dispute with you had paid this by credit card, correct?
That's true. I paid it by American Express and then I stopped payment on it.
Right. So after you had paid it, you actually went back and you made a dispute. And in doing so with American Express, you had to say that the services that he claimed were provided were not actually provided.
Correct.
Okay. So this was, you had to make that affirmative representation to American Express in order to get American Express to reverse that payment.
Correct.
And they did, correct? So that's why he sued you.
Correct.
Okay. Okay. That's all the questions that I have right now. Thank you.
Mr. Dinan, do you have any redirect?
No, I don't.
Okay, my next step will be to open it up to the panel to ask questions. So first, Mr. Perlmutter, do you want to ask your questions first?
I don't have any questions.
Okay.
Mhm.
How about you, Mr. Holtz?
Yes, thank you. Mr. Wiz, thank you for your testimony. Just a question about the incident in Rochester. What was the actual charge? I know you pled to disorderly conduct. Do you recall what you were charged with?
I don't recall the actual charge. It might have been assault. I'm not sure.
Okay. Did an actual physical altercation take place?
Mostly just kind of posturing, if you will, in the coffee shop when he came in. So
Was the other individual charged with anything?
no.
So how was it that you were arrested?
Because I went outside. I was trying to get a video of him because I thought he was gonna run back to his car, And so that's, I actually called 911. So I'm not sure exactly.
Okay. And they asked you a couple of things about your divorce attorneys. How many divorce attorneys actually did represent you in the course of that litigation?
Oh, 1, 2, maybe 6.
Okay. I have no more questions. Thanks.
Thank you.
I have a couple questions. In the course of the custody litigation, were there psychological evaluations done?
Yes.
Who did the psychological evaluations?
Oakland County, and I'd be happy to provide a copy of that.
When was it done?
Oh, I'm not sure of the date. It was early on.
Give me an approximate date. I won't hold you to the specifics.
Okay. Probably 2 years, maybe into the litigation. I mean, I could find it for you.
It's okay. I'm just trying to get a general idea of the timing here. There was some discussion about the marriage certificate in 2009, and what year did Ms. Plosky file the divorce complaint against you in Oakland County?
Well, I filed first, and then she convinced me to withdraw, and then she filed.
What year?
2007.
Okay, so in 2007, there's a divorce action that started, and in 2009, there's a marriage certificate that's signed, which is is that the timing?
No, because 2017. I'm sorry. What could you?
So yeah, I'm trying to understand the timing here. You said that the psychological evaluation, no, that the divorce complaint was filed in 2007, and
I'm sorry.
go
Not
ahead.
7. It would be 2017.
Okay.
Yeah. Sorry.
And it's okay. And then what's the date of your judgment of divorce? For Ms. Plasky?
2018, we came to a consent judgment of divorce. I can get you the exact date if you want.
Don't need it. Don't need it. If I do, I know where to find it. So most of the behaviors that and the litigation occurs after the entry of the consent judgment?
Yes, because that's when we really started fighting about child custody. And like I mentioned,
okay, let me just ask the questions. And so the psychological evaluation was done during the period of time before the divorce was final. Is that the way I understand it?
I believe so. Right before she filed to change, because I recall that they were waiting for the psych eval from Oakland County, and then when it came back, and it was really favorable to me, we were surprised that she still filed for change of custody, and we brought that up in our answer, and the judge just kind of discounted it. Like,
what judge do you have in that case?
First we had, I forget the names. Valentine was the first one, and now we have I can't think of her name offhand.
Okay. Let me go back to all that's public record. If I'm dying of curiosity, I can find it out myself. So the you list and you admitted in some of these complaints, like the first complaint that's made against you by the grievance administrator and that you resolved through consent, you admitted some pretty poor decision-making. Is that fair to say?
Yeah.
And so, our concern not only is the past behavior, but is the future prospect for better decision-making or continued poor decision-making. And so what I really want to know is, tell me what specifically right now, as we sit here, what have you done to prevent this poor decision-making in the future?
Well, I sorted out my employment with Fargo. I'm very happy. I have a 5-year-old, Alexander, who I drive to school every day. I will be coaching his baseball team. I volunteer at his school. I essentially have a whole new life. And like I said earlier, I don't know if it sounds bad, and it probably does to a certain extent, but I kind of had to wall myself off from texts and my ex. And
so this is my concern. So you talk about these things that are in place in your life. You have a job, you have a new wife, you have a son that you love. All those are the things that were occurring in 2017, 18, 19, 20 and forward that caused these problems. And so my question again is, what have you done? What have you done personally to prevent this poor decision-making? So for instance, wife number 3 leaves you and there's a new custody battle. That is not outside the realm of possibility in Michigan or any other place. What have you done as we're sitting here to prevent the kinds of behaviors that cause you to be sitting here?
Well, first off, my current wife is not like crazy religious. And secondly, I've reflected a lot. I mean, I've thought about this a lot. I've lived a lot through it, and I've learned a lot. And
let me stop you there. What have you learned?
I've learned that I have to be held to a higher standard, and I have to be responsible for my actions and not play the tit for tat sort of game. And my mother recently passed away, and I reflect how she was with my sister and I, and I've tied it to how I am with Alexander and with my current wife, and with me focusing on them. And I've made a lot of bad decisions in the past. I grant you that. But you can see that they're all quite a few years ago, and they were right in the heat of that, where I was caught up with things, and I saw things that were just beyond my belief. And not
okay, let me stop you. So just looking at it, and I'm not trying to be super hard on you, but I think in a way, I really want to know I need to know what your relationship to the truth is. So for instance, you want to be a patent attorney, and you've said that's a professional life versus personal life, but you will still have clients, you will still file documents, you will file legal documents. And in all of those situations in the past, when things have gotten tough, at least from your testimony, you have lied. And so how are we able to go forward? What's your statement about that? How are you going to do something different?
Because I have almost 20 years of practicing patent law, where there was never a single issue with clients or with the patent office or with filing documents or communicating with clients or examiners at the patent office. And one does not beget the other. And that's where I was having trouble before, is that I didn't think there would be such consequences associated with the divorce in my professional life. And people would tell me who got divorced that it's like, oh, it's a game. You have to play the game. And from what I saw as part of the game, it just flabbergasted me what was going on and how dishonest seemingly everyone was. And I got caught up in that. But that's not me. That's why I said, I have a new life. And in a lot of ways, I'm coming back to the old me before all this happened. And there's been no issues whatsoever, really, recently, since that time period. And
let me ask you a couple questions about that. Do you have ongoing litigation in Oakland County with Ms. Plosky?
Well, child custody is always open.
Well, no, what I mean is, when's the last time anyone, you or her, filed a motion in that case?
Maybe a year ago.
Okay, so in 2025 at some point?
Yes.
All right, and any other litigation, any other fee disputes or anything else happening in Oakland County?
No.
Any other county in the state?
Well, there's the issue with my financial advisor in Connecticut.
That's still ongoing?
Yep.
Okay. All right. And so you talked about a person when Miss Lindsay was asking you about counseling, you talked about a person that you would talk to on the phone, and Brenda O'Brien.
Yeah.
And what company does she work for?
I don't know. I think she's independent, but she was recommended as being one of the parenting time supervisors. And she came to side with me, quite frankly. And then when my ex and I went to an arbitration, that was the main thing in the arbitration, is that my ex wanted to get rid of her as a parenting time supervisor. And I agreed because I was trying to move forward. And again,
Okay, so she was someone that was appointed by Oakland County, or you guys agreed to her?
Oakland,
Pardon?
Oakland County, correct.
Yeah, Oakland County. And so she did some parenting time supervising, and then you would speak to her on the phone occasionally about those issues, and you came to see that as counseling. And it might be. I mean, really, I'm familiar with them, so it might be in the way of counseling. Is she? Do you know if she's a counselor?
Yes, she is.
Okay, and and she's no longer affiliated with your case.
Correct.
All right. When's the last time you spoke with her?
She came to Alexander's baptism.
And how long ago was that?
4 years ago or so.
All right. And so other than that, have you sought out any other kind of counseling?
No.
All right. Have you done any kind of ethical, any continuing legal education on ethics, anything like that?
To be a volunteer in school, I had to take different classes.
Right, but I'm talking specifically here about legal ethics.
Legal ethics, no.
Okay. And the minister who did in the whole 2009 situation where you brought in a marriage certificate and the minister signed it and you and your then wife signed it, and witnesses in the Bible study, is that minister still practicing?
I don't know, but the main pastor of my then Plosky's church, who was like his boss, I guess you would say, he was found to be what do you call it? Like plagiarizing Bible mess, or whatever. What do you call it? Like
sermons. Okay, so but not that particular. I think his name is Maroka or something like that. Oh, okay, he's not, as far as you know, he's still a pastor.
I don't know. It was, again, it was sort of a,
Okay, that's all, that my question was just as far as you know, and I have another question, like, as far as, personal character witnesses, did you supply any names of, or letters from people who are personal character witnesses? Because I don't remember. I read through this stuff some time ago, and I just wondered if you supplied anybody who might have given a letter or something about character reference.
no, I thought having David Motto testify was one aspect, and then the other partner at Fargo, having him send a letter, that would be sufficient.
Remind me of the partner's name again.
Tom Kading.
CADE, correct?
Kading.
Oh, I'm sorry. I misunderstood you. All right. All right, I have no further questions. I'll go send it back to the panel, and just in case they have questions. If not, just shake your head. None. None. Oh, okay. All right. How about a short, anything else? Are there any other witnesses by either side?
No, Madam Chairman, the petitioner rests.
All right. What about you, Miss Lindsay?
No, we do not. I just want to point out, I don't believe any letter from Mr. Kading is part of the record. I'm not aware of it.
Okay.
It was submitted directly to the ADB. It wasn't sent to me.
Oh, okay. All right. I forgot about that. All right. So I don't know if you want to move to admit that, Tim.
Well, then I for sure have it, right?
Okay. All right.
I don't know. We'll dig it up, and I'll let you know what, because I'm not gonna. I mean, Mr. Dinan, do you have a copy of it, Mr. Dinan?
It was provided to me by the ADB. I did not receive an original of that. So
Do
it said-
you
was
want
sent-
to? Do you want to move its admission so we consider it, or because your client thinks that that's somebody who provided character reference for him?
I would move to admit it at this time.
Okay, so Mr. Permoy, oh, I'm sorry, Gary, I mess up your name every time. It's, but do either one of the panel members remember the letter, and do we want to take that under advisement as an admission, or do we, that's what I'm trying to figure out, because I cannot remember the letter.
I don't remember the letter either.
Okay.
I wouldn't be opposed to that being admitted. Is there an objection on the part of the grievance administrator?
I do not object.
Well, then let's just admit it, and then we'll consider it part of the record. All right, but make sure we have a copy of it, like in some official capacity.
Certainly.
Thank you.
And just to clarify for the record, I don't think it's necessary. The grievance administrator's report and the supplemental report and all the appendices under the court rule are part of the record. So I don't think it's necessary to move for their admission, but if that clarifies anything, but otherwise I would, okay.
Yeah, I don't think they have to be admitted like that, and they're just part of a reinstatement record, so.
Okay. All right. Then I have nothing further
Nothing further. Okay, so,
no witnesses.
all right, so how about we move to short closing argument?
Certainly.
And we'll start with Mr. Dinan.
Thank you. And again, thank you for your time and preparation today. We appreciate the good questions that you asked and a chance to offer David's position today. So he had 3 discipline matters tied to his personal conduct. These are not matters that dealt with client funds, neglect of client work, dealing with trust funds, or anything to do with his professional work as a patent lawyer. Directly and indirectly, all of this was tied to the breakdown of his marriage, the litigation, the loss of custody of his son, and the mounting financial pressures that arose once he was suspended from practice. Before he was married to Ruth Plosky, he had a pretty low-key existence. He was active in the patent bar, in the Michigan part of the patent bar, and had a good reputation within the community of other patent lawyers and engineers. The business of breaking up his marriage dealing with this divorce, and the financial pressures caused him a great deal of frustration, as he testified to today. So when his suspension began in October of 2021, it was tied to his divorce from Ms. Pulaski. He talked about the circumstances today and the original botched divorce from his first marriage and his attempt to remedy it by using a false certificate. He also testified about the issue of the notebook and why he took it. I think I need to stress the fact that it was a matter that the court had ordered produced, and she was not doing so. And while it was improper for him to use self-help techniques, nonetheless, that was something that he was entitled to. And I think that was certainly part of his motivation to get that notebook back. The PPO hearing is also tied to the divorce in that first suspension. He explained his actions, explained the nature of the testimony, and the fact that he took responsibility for all three of these matters as part of the 180-day consent suspension. The Rochester coffee shop incident that led to his 2023 conviction, again, he testified to it today. He took a plea. He accepted responsibility for that. He went through his probation successfully and was discharged. The last matter involving the 18-month suspension was, again, a series of acts that were improper and dishonest. And I think my client indicated clearly that he was the author of his own disaster. He's the one that tried to get into a place and hopefully work something out, knowing that he was going to lose his ability to practice patent law in the near future. As to his finances and other personal matters, the petitioner has satisfied his bills and obligations as to the contested billings and continued demands of his former spouse and the support issues that came out of that. And so today he doesn't have that problem. So as we look at the requirements for reinstatement, first of all, he certainly desires to be reinstated. He's made that clear. The term of all the suspensions have now passed. He has complied with the orders of discipline. His conduct has been exemplary. He possesses an understanding and an attitude imposed upon all the members. I especially appreciate Ms. Tallarico's questions today about his duty to be truthful and forthcoming, because that is probably the most key issue of them all. And he has learned, albeit the hard way, that when he tries to do things his own way, when he tries to shortcut things, that it ends up being a disaster for him. And he's done that 3 times. I believe that he has learned his lessons from that, and he can be taken, safely recommended to the public as a counselor and an officer of the court. I think he has demonstrated today that he understands the attitudes and the that he is supposed to have, and it's imposed on all members of our bar. He'll defer to the Board of Law Examiners when he's determined whether he needs to resit for the bar exam or not. And there's no need to reimburse the State Bar of Michigan's Client Security Fund, as this did not involve funds or client issues. He's really had a long time to consider his conduct. And yeah, there's a big difference between being a law clerk and being a patent lawyer. He had to let go of the one positive and fulfilling part of his life, professional life, when he was suspended. And he wants to come back. He's had the opportunity to look back on his life, look back on the events of the divorce, the other negative things that were happening, and take away the important lesson that he is ultimately responsible for his conduct. No one else. Yes, there are circumstances that he explained today, and I know he wanted that opportunity, but he ultimately knows that he owes a duty, first and foremost, to conduct himself in a manner that's proper. The elements that disrupted his personal life are behind him now. He's remarried, he's raising his son, he has steady employment. This is the first step of many steps he's going to have to take if he ever wants to return to the practice of patent law. He's satisfied his obligations to the courts and to the discipline system. So please give him an opportunity to return to practice. Thank you very much.
Thank you. Ms. Lindsay?
Thank you. So the Michigan Supreme Court said in Grievance Administrator versus August that to grant a license to practice in Michigan, the panel affixes its stamp of approval on the petitioner. To do so for someone who has committed serious misconduct requires a searching inquiry into the causes of the misconduct and the most convincing showing that a genuine transformation has occurred. The investigation and this hearing have revealed several issues. First and most basic, Mr. Wiz has not complied with the terms of the order of suspension. So we're looking at all of the 3 orders of suspension, and we know that he did not comply with the 180-day order of suspension because this hearing panel in the 18-month suspension found that he held himself out as an attorney while he was suspended. He also lied in his last petition for reinstatement. So he cannot comply with MCR 9.123B4 on a most basic level. Second, under 9.123B5, his conduct since the order of discipline has not been exemplary and above reproach. We know that the 30-day suspension and the 18-month suspension both occurred while he was suspended from the practice of law. The panel has also been presented with additional evidence, including Appendix G and S through V, which are orders from the circuit court about additional conduct that took place during the time that he was suspended. And somewhat to a lesser extent, the lawsuits by the former attorneys. All of that is part of the record and must be considered. Under B6, he has not demonstrated a proper understanding of an attitude towards standards that are imposed on members of the bar and shown that he will conduct himself in conformity with those standards. The 2 major issues here are his dishonesty and his disobedience of court orders, and I'll address those more specifically in a moment. And then finally, under 9.123B7, taking into account all of his conduct, which includes before, during, and after, can he be safely recommended as a person fit to be consulted by others to represent them in matters of trust and confidence, and in general, and to aid in the administration of justice as a member of the bar and officer of the court. So I would like to talk about the evidence and how he has failed to meet these. The first issue is that, so as we're to look at the nature of the misconduct, and the nature of the misconduct is really dishonesty. There are multiple acts of dishonesty that Mr. Wiz has engaged in, and it began in 2009. So he admitted the first divorce from his first wife was not acrimonious. It was actually amicable. And he was marrying his second wife. So at that time, obviously, there was no stress because he was reaffirming it by obtaining a second marriage certificate. And rather than come clean, he admitted he didn't want to tell the pastor, religiosity, whatever issues, he didn't come clean. So there's no evidence that he was undergoing the stress of the parenting time issues. And yet, rather than just admit that a mistake had happened, and it wasn't even his mistake, it was a divorce attorney who gave him a false certificate of divorce. But rather than admit to his then, who he believed to be his wife, that a mistake had happened and just get remarried, he presented a new certificate, and under the guise of cleaning up an error, he had everyone sign it, and he filed it and said, and even testified today and testified in December, that there was a new marriage, essentially a new marriage ceremony. But he finally admitted today there was no marriage ceremony. Everybody signing a new certificate under the guise of cleaning up errors is not a marriage ceremony. Then in 2016, he stole a notebook from his wife's purse or briefcase. He testified today that he believed that he was entitled to it as an officer of the court. And this is important because one of the findings that this panel has to make is that he will aid in the administration of justice as a member of the bar and an officer of the court. This is not something he believed back in 2016 and now understands was wrong. He believes even today that as an officer of the court, that he could engage in self-help and steal a notebook that he believed he was entitled to. There is no evidence that he was actually entitled to it. The only evidence in the record is that it contained attorney-client notes from his wife and that he never returned it. There's an admission that it was larceny. So there's no question he was not entitled to it. And so whatever attempts there have been to say that he was entitled to it under discovery, that there's no evidence to support that. Today, he continued to justify sewing a recording device into his son's backpack and eavesdropping on these conversations, private conversations that his son was having with a therapist. He continues to justify that today, which means there's no assurance that he will not do the same thing in a similar situation because he believes he is entitled to. The ends in his mind justify the means, even if those means were illegal conduct, which again is in the hearing panel order and was admitted that he engaged in illegal conduct. It was never justified. And I believe he said there was no findings, but that led to the very restricted parenting time. So there were consequences, both personally and obviously in the order of discipline. There were findings that he repeatedly and knowingly disobeyed court orders. And this was not just about parenting time. This is about a variety of issues. And that has not been addressed. There's been no evidence and no testimony put forth where he says he will now abide by court orders and understands he has to do that. In 2016, he also testified falsely. That's perjury. He did this. He believes it was justified because it was an acrimonious divorce. But when under oath, we have to testify truthfully, and he chose not to. Again, then in 2022, the judge, and this is Appendix G, made findings that he testified untruthfully repeatedly in the parenting time dispute that was going on. So much so that she said she could not believe anything that he said. So I would urge the panel to re-review that order as well. Then in March of 2022, he engaged in a racist verbal attack and physical assault. Again, the records are there. And I would ask that the panel look at Appendix N, which is the police report is attached to that. And also the hearing panel findings, because the hearing panel reviewed the report and found that his description of it simply wasn't true. The judge who heard this in the parenting time matter said she reviewed the entire record, including the recordings and everything, and said his description simply wasn't true. So he continues to make that same description of events today and fails to take responsibility. He said he didn't believe there was an assault, but the records show that he was originally charged with assault because there was shoving involved. So when asked about it today, he didn't testify about that. And that is in the record. In Appendix N, there's the police report attached. Finally, the 18-month suspension really had nothing to do with the divorce. By the time he submitted his resume to Gentex, he had lost his job because of the 180-day suspension, but there's no evidence and no testimony to support that he was under stress of the divorce and that that's what caused him to lie to Gentex in order to get a job. Also, no evidence that he was under the stress of the divorce and that's what caused him to lie when he submitted a false personal history affidavit to the Attorney Grievance Commission and just failed to reveal that evidence of employment. Obviously, if he had revealed it, it would have become clear that he'd held himself out if we got those records. And so eventually we did discover it, but not because he reported it. So there's throughout the interview process, in that submitting of a false resume wasn't the only thing. He testified today that he had the lengthy interview process. He did not tell them. He accepted the job, said that maybe he could clarify it after. He still did not tell them. He also didn't tell them that he was about to lose his USPTO license because he was undergoing reciprocal discipline there. So he took the job knowing he wasn't qualified by their qualifications and simply didn't tell them. They fired him for an unrelated reason, but who knows if they ever would have discovered the suspension if they hadn't fired him. Then we have the circuit court findings and Appendix G, where the judge found that Mr. Wiz provides falsehoods with ease and without remorse. And he is without credibility. And the court finally said that the court could not trust any representation he makes. And that's at Appendix G at pages 21 and 28. So given all the misconduct, the panel must make a finding that he has demonstrated a searching inquiry into the causes. And basically, he says it was caused by the stress of the divorce, the parenting time proceedings. Those are over, so it's not going to happen again. But that's not sufficient because obviously we can't determine when we might face stressful situations. And he hasn't said that he has actually changed as a person, just that he's removed the stress. The other thing is, he said he was married in 2017 to his third wife, and that his son is going to turn 6 years old, I think he said in June or July, which means he's had this son for more than 5.5 years. So the things that are good in his life right now have been there for years, but much of this misconduct took place in 2021, 2022, etc. And these good things in his life were there then. They didn't prevent it. What we see is time and time again, when given an opportunity, Mr. Wiz chooses the easy path. And if that means dishonesty, that means even stealing, he justifies it because in his mind, other people are doing bad things too. And even today, he has justified his misconduct. So he has not met his burden because he hasn't shown that he's learned his lesson. He hasn't shown that his conduct will be different. And he hasn't shown generally a genuine transformation. He's just said that the stress has been removed. He also says that he's never had an issue with a client or the practice of law, but obviously every attorney who has been suspended for over 180 days has the same burden. We don't eliminate some of the standards just because the conduct didn't relate to client practice or a client issue. There have been many attorneys who have been suspended purely for, let's say, criminal conduct that is unrelated to the practice of law. Every attorney who has been suspended for over 180 days has to go through this process. So at bottom, Mr. Wiz cannot meet his burden of proof by clear and convincing evidence with regard to standards 9.123b4, 5, 6, and 7, because he does not have an understanding of the causes of the misconduct and he has not presented evidence of a genuine transformation as required. Thank you. I'm wondering if our chairperson froze on the screen. It looks like it.
She may have.
Yeah, definitely looks like that. Appreciate it.
Here we are.
What happened?
You were froze up for a little bit.
Yeah, I thought it was all you guys. I saw Sarah stop mid-sentence, and then I thought, okay, I was calling out, but no.
Oh.
Okay, Sarah, I'm sorry. Sorry about that.
I apologize. I did end my argument, but I don't know at what point.
It's okay. If it's on the record, it's fine.
Okay.
What I'd like to do, is that it for everybody? Anything
Yes.
else? Okay, so what I'd like to do is meet with my panel shortly, and I want you all to stick around because we'll come back and tell you what's next. Okay?
Okay, thank you.
Thank you.
All right. I'll open the breakout room for the panel right now.
Thank you very much. Okay, is everybody accounted for?
We are just waiting for Mr. Holtz.
Holtz, right. And there he is.
Okay. It looks like we have everyone. I will lurk into the background.
All right, thank you. So thank you, counsel, for both your work on this. What we would like is for proposed findings of fact and conclusions of law or statement of law. We don't want it long. I'd like 5 to 6 pages at the most. We also would like it so that you refer to exhibits, but do not copy them and attach them, because unless you think we don't have it, we likely have it. The only thing that I can think of that we do not have is that the last letter that we talked about that will wind its way through to us. That we would like that done within 21 days of today. So that is, let's see, 1, 2, that's, I think, April 6th. So 1, 2, 3. Yeah, April 6th. And there's no, and we want the due date to be the same, because it's not like there's a lot of, there's no fight over what statute or what rule is applicable. So just go through that and tell us what your proposed findings are, and then and any law that you think is appropriate. Once that's done, the panel will meet, and we will discuss those things, and we will then issue a decision. If we have any questions about anything, we're going to try. We recognize that this has been gone on, and that there's, people need to live their lives. So if there's questions about anything, I think go through the board, go through Owen, and he can make sure that we, that if it's appropriate, that we answer those questions for you.
Just one issue, Ms. Talarico. So I will make sure that our findings and issue and statements of law be issued or responded to timely. But I'm leaving the country on the 5th.
Okay.
And I'll be gone for 2 weeks. So I'm just not going to be available for 2 weeks after, and I'll be back around the 21st of April.
Okay, we won't do anything. First of all, that's very nice of you to think that we would be that prompt. I mean, we are prompt. It's just that the more lawyers you put on the case, the harder it is to get dates.
Yes.
Thank you for letting us know. We will not do anything that you will be in town by the time it all floats through. So
thank you.
Sure, yeah.
I have just one question. If you want us citing the transcript, I don't know if we'll have it in time.
Well, not the transcript. I don't know. Yeah, that's a good point. I don't really. Oh boy. Mr. Trudell, how soon do they get the transcript? And usually,
normally it's 10 days, but we do rushes for like 3 days. I think that's the fastest we could do.
We're not going to rush it, because that puts costs on the board and on everybody, and so and you just personally. So how about we Owen, what do you have to say?
I think I can provide the transcript to the parties as soon as it's received from the court reporter. And if we do 21 days from that date, or perhaps maybe truncate that a little bit and do 14. But I'm just letting you know I can effectuate transferring the transcript whenever we receive it.
Okay, so why don't we do this? We'll do it, let's say, assuming 10 days from now, give or take, the transcript comes in. Then Mr. Dinan's going to be going out of town. So he'll be going out of town on the 5th of April. And if 10 days from now is the, let's say, March 30th-ish. He's out right after that. So I think we have to push that, due date for counsel for, Mr. Wiz and for the grievance administrator out to the end of April. I think now counsel, there's enough here that you could start it. I think I'm not trying to tell you how to do your job or either one, but that it can be then filled out with the transcript if that when that comes in.
And that's fair. I just, again, when you try to plan these longer trips, you have to do it months and months and months ahead. So
No, yeah, I know. So is that when do you get back, Mr. Dynan?
I'll be back in the office on the 21st.
Okay.
I'll be in town before that, but it's a 20-hour flight. So
Good for you. Okay, here's how it sounds to me. Like there's the notes of testimony, just a couple of people have testified, and you have the grievance administrator's investigative report and supplemental. So you have material to begin. Then the transcript comes in at day 10, which would be around let's say the 26th, 27th, somewhere in there. You can do what you can do. And then we will not expect your findings of fact or statement of law until May 1st. All right? Is
that's
okay?
agreeable. Thank you.
All right. Is that okay with my panel? Yes.
Yeah.
All right. Okay. And Owen, will those dates be reduced to writing into an order?
Yes.
All right. Then I think we're done for today. I really appreciate everybody's patience and I hope good travels to you, Mr. Dynan.
Thank you.
And we'll meet again soon, I'm sure.
Yes, thank you again for everyone for your time.
All right.
Thanks very much, all.